Good morning, ladies and gentlemen. This session of the Russell Tribunal will be largely concerned with the facts of Operation Protective Edge. We will hear evidence of the killing of some 2,000 Palestinians, of which 70% were civilians. We'll hear evidence of the wounding of civilians and of extensive damage to property and to public services. We're also going to hear evidence about the weapons that were used in the operation and the suffering of the people, and also of the intentions of Israel. But this will all be in the context of international law. Fact and law will interact with each other. I think it's important to stress that the Israel-Palestine conflict has always been characterized by conflicting legal argument. And Operation Protective Edge continues in this tradition. So I'm going to start this morning's session by outlining very briefly the main legal arguments and main legal problems that will arise during this session. And I'm going to deal with the following subjects. First of all, the status of Gaza as an occupied territory. Secondly, the siege of Gaza as collective punishment. Then the question whether Operation Protective Edge was an act of self-defense on the part of Israel. Then the accountability of those who were involved in the Gaza conflict. Then the crimes that were possibly committed, the courts that may try such crimes, and finally, the responsibility of states for their actions. But I begin with the subject of occupation. I think it's important right at the beginning to understand the status of Gaza. Gaza is not an independent state like Lebanon or Jordan. Israel accepts that Gaza is not an independent state, but it argues strangely that it is a hostile entity. This is a concept unknown to international law. It's not supported by any state, and to make matters worse, Israel has never explained exactly what it means by describing Gaza as a hostile entity. But in international law, the status of Gaza is very clear. It is an occupied territory, and it has been ever since Israel expelled the Egyptian administration from Gaza in 1967. Occupation, military occupation, is a concept or status recognized by international law. It's governed by the Fourth Geneva Convention of 1949, to which Israel is a party. And this provides that a state may occupy a territory acquired in armed conflict pending a peace settlement. But this occupation is intended to be temporary, which means that the parties must negotiate in good faith to reach a peaceful settlement to the conflict. But we all know that Israel has failed to enter into good faith negotiations with Palestine, and so in the absence of a settlement, Gaza remains an occupied territory. And it's also part of the Palestinian occupied territory, together with East Jerusalem and the West Bank. And this has been recognized by the Security Council of the United Nations, and this is accepted by all states, with the possible exception of Israel. It's true that in 2005, Israel withdrew its armed forces and its settlers from Gaza, but it remains in effective control of the territory. And effective control is the test for occupation under international law. Israel maintains control by control over the land crossings into most of Gaza, by control over Gaza's airspace and sea space, and by conducting regular missions, military missions and incursions into Gaza and by firing rockets into Gaza. So it remains in effective control. It has remained in control ever since 2005, despite the fact that it has no soldiers permanently based, situated in Gaza. But today, a state may maintain effective control from outside, and as I've indicated, Israel does maintain control from outside with the assistance of modern technology. So Gaza remains occupied territory. All states, with the exception possibly of Israel, accept that. So does the United Nations. First question. Secondly, there's the siege of Gaza as a form of collective punishment. In 2006, after Hamas took control of Gaza, Israel imposed a blockade or siege on Gaza. As we know, it has seriously restricted the supply of fuel into Gaza, which has had a negative impact on industry and on agriculture, on the operations of hospitals, water supply, and sewerage. Israel has also restricted the import of goods to Gaza, restricted the import of medical supplies and some of the most basic foodstuffs and household goods. And this has affected all aspects of life in Gaza and has resulted in massive unemployment and poverty. Finally, it has also restricted the supply of cement into the Gaza Strip, which has prevented the people of Gaza from rebuilding their homes and structures which have been destroyed by Israel on previous military incursions. Why has Israel imposed this blockade? I believe that it has done so in order to compel or to persuade the people of Gaza to overthrow Hamas, to get rid of Hamas. But this amounts to collective punishment because the people of Gaza are not punished for having committed any wrongdoing, for having committed any crime. All they have done is, in a democratic manner, to elect Hamas, which Israel does not approve of. And they are punished for the fact that Hamas remains the governing authority of Gaza. And this is clear collective punishment which is prohibited by the Fourth Geneva Convention. So not only is Gaza occupied territory, it's also territory illegally occupied. Next, we come to the question of self-defense, which is very important because during the conflict, Israel portrayed its action as that of self-defense, and it saw itself as the victim of an attack by the Palestinians. To make matters worse, this was endorsed by the President of the United States and by both houses of Congress of the United States in unanimous resolutions. As we all know, the United States Congress cannot agree on anything today except on being unkind and harsh towards the Palestinians. And of course, one must remember that many European leaders have also followed the United States in accessing in this respect. But this is based on two very faulty premises. First of all, it's wrong to argue that Hamas started the conflict. We all know that the conflict started as a result of the arrest by two Hamas operatives, generally believed to have been operating on their own without the endorsement of Hamas, which resulted in the kidnapping and killing of 3 Israeli teenagers. And that was followed by a brutal response by Israel against Hamas, which it accused of being responsible for the kidnapping. It arrested Hamas office bearers in the West Bank, welfare officers, and there was a massive crackdown on Hamas in the West Bank. And that provoked Hamas into responding with rocket fire. But one cannot therefore argue that the initial attack was launched by Hamas. It was largely the response of Israel, which was determined to destroy the government of national unity, in which Hamas is a part, and this was the way in which it set out to do so. So that's the first faulty premise. The second is that it responded to rocket fire from an independent state. Now, had it been responding to rocket fire from, shall we say, Lebanon, it would have been entitled to use force in self-defense. But Israel is the occupying power of an occupied people. So when it uses force, it does so in order to maintain the occupation, in order to enforce the occupation. It's the same sort of enforcement action taken by Germany during the Second World War in respect of Belgium and France, in respect of the resistance movements in Belgium and France. I think it's important to see the rocket fire and the tunneling on the part of Hamas as acts of the Palestinian resistance movement, the resistance of an occupied people to the military occupation. And Israel's response must be seen as the enforcement of the occupation and the suppression of the resistance of an occupied people. I think it's very helpful to look at it in the context of the German occupation of the Second World War. If, for instance, the French resistance had had the ingenuity to build rockets and to fire rockets into Germany during the Second World War, we would all have applauded the French resistance for its courage and its ingenuity. But unfortunately, Hamas is not judged in the same way. It is simply seen as a terrorist group and not as the resistance movement of an occupied people. Next, I turn to the subject of accountability. A state that seeks to enforce its occupation may use force to do so. But at the same time, it must comply with the rules of international humanitarian law. And this also applies to the resistance forces. This means that both Israelis and Palestinians are obliged to comply with the rules of international humanitarian law. Essentially, as I will show, these rules seek to ensure that military operations distinguish clearly between military targets and civilian targets, and that every effort is made to protect civilian life and property. Failure to comply with these rules of international humanitarian law may result in the prosecution of those responsible, those individuals responsible, by an international criminal court or a national court applying international humanitarian law. It must be stressed at this stage that states are not criminally responsible. It's only individual leaders and operatives that incur responsibility or criminal responsibility. In this session of the Russell Tribunal, we will focus on the crimes of Israel for two reasons. First of all, because of the disproportionate scale of Israel's assault on the civilian population of Gaza. In Israel's assault, we know that over 1,500 civilians were killed, and there was considerable damage to civilian property, whereas in the case of Israel, only some 7 civilians were killed. So there is a great disproportion in respect of the harm and damage caused. And the second reason that we will focus on Israel's crimes is because the Russell Tribunal has always been concerned with the occupation and with bringing an end to the occupation of Palestine and Gaza. But at the same time, I think we must make it clear that this focus of attention should not be seen as a denial of the accountability of Palestinian militants for indiscriminate targeting of civilian objects in Israel, and we must also not forget that in its execution of collaborators, it violated rules of human rights law. But the focus will be in the session on the wrongs and crimes of Israel. And this brings me to the subject of international crimes, what we will be talking about in the session: war crimes, crimes against humanity, and genocide. Israel is subject to the rules of customary international law on this subject. It's true Israel is not a party to the Rome Statute or to the first additional protocol of 1977, which defines international crimes, but it does accept the rules of customary international law, which set out clearly the definition and content of these crimes. The first crime we will look at is that of the war crime. Broadly, war crimes include indiscriminate and disproportionate attacks on civilians, the killing, wounding, and terrorization of civilians, the wanton destruction of property not justified by military necessity, and attacks on hospitals and ambulances and other means of humanitarian assistance. We will hear evidence of attacks on civilians that cannot be conceived of being military targets. Israel's claims that civilians were deliberately put at risk by Hamas, which it argues placed rocket launchers near to civilian areas, simply cannot explain the number of civilians killed in the conflict. Nor can Israel's claims be reconciled with the rule of customary international law, which prohibits the launching of attacks which may be expected to cause incidental loss of civilian life or damage to civilian objects, which is grossly excessive. That is, excessive in relation to the military advantage anticipated. We will hear evidence of the terrorization of the people of Gaza by continuous bombardment. We will hear evidence of the wanton destruction of property in Gaza, which resulted in the destruction of some 17,000 homes and the partial destruction of 37,000 homes. And there was the destruction of the power plant and bombing of mosques and schools and so on. And then there was also Israel's attacks on hospitals and ambulances. So I think it's pretty clear that Israel will have to account for its commission of war crimes. The evidence points very strongly in favor of the commission of war crimes by the Israeli Defense Forces. Crimes against humanity. A crime against humanity is committed when it involves murder, extermination, persecution, or any other humane act that intentionally causes great suffering when committed as part of a widespread or systematic attack directed against a civilian population with knowledge of the attack. Murder has its normal, customary meaning. Extermination means killing on a large scale, but it also includes the infliction of conditions calculated to bring about the destruction of a whole or part of a population. These acts must be widespread and systematic. We are going to hear evidence of the killing of civilians and the inflictions of conditions of life calculated to destroy part of the civilian population of Gaza. And it's common cause that this was all done in furtherance of Israel's policy and that it was systematic and widespread. So again, there's a strong case for Israel to meet in respect of crimes against humanity. This brings me to the subject of genocide, the crime of crimes. Great care must be taken in considering this crime. Nevertheless, the Russell Tribunal believes that the Operation Protective Edge was of such a serious nature that it is necessary to consider whether the crime of genocide was committed by Israel itself or by individual members of government with a genocidal intention. The characteristics of the crime of genocide will be examined in detail by Paul Behrens, who will follow me. Suffice it to say at this stage that it involves killing, causing serious bodily harm, or inflicting conditions of life calculated to bring about the physical destruction in whole or in part of a national, racial, or religious group, but not of a political group. Unlike the crime against humanity, genocide must, however, be committed with the intention to destroy in whole or in part a people or a group, but not a political group. And this, of course, is a difficult concept which we will grapple with in this session. Those are the three crimes that we will consider. Which court might consider these crimes? Well, in the first place, there's the International Criminal Court, but unfortunately, neither Israel nor Palestine is a party to the International Criminal Court, so it doesn't have normal jurisdiction over international crimes. There is a suggestion, strong suggestion, that the Palestinian Authority is on the verge of becoming a party to the Rome Statute of the International Criminal Court. One hopes that President Abbas will have the courage to go ahead with signing the Rome Statute. The Security Council could refer the matter to the International Criminal Court, but this is impossible because the United States would veto any such referral. In the absence of an international court, national courts may exercise jurisdiction, but this is not very satisfactory for a number of reasons. First of all, states, prosecuting authorities of states generally lack the political will to prosecute. And then there's the problem of immunity. Heads of states and government and senior government officials all enjoy immunity before domestic courts, which means that only the foot soldiers and the military leaders too might be prosecuted before national domestic courts. Whereas when it comes to the International Criminal Court, the political leadership of Israel would also be exposed to prosecution. There's also the Geneva Convention of 1949, which should not be forgotten. In that convention, to which every state in the world is a party, states are obliged to prosecute grave breaches of the Geneva Conventions wherever an offender lands in its territory. And many of the crimes that Israel has committed are grave breaches of the Geneva Convention. So there is an obligation on states to prosecute members of the Israeli military for committing grave breaches of the Geneva Convention. Sadly, this obligation has never been taken seriously by states, but I think it's important for civil society to put pressure on governments to take such action. So that's a way in which individuals might be prosecuted. Again, it's important to stress that states may not be prosecuted for international crimes. That brings me finally to the subject of the responsibility of states for Operation Protective Edge. There is, first of all, let's look at the responsibility of Israel. There is no international criminal court to try states for committing international crimes. States do not incur international criminal responsibility. Only individuals may be prosecuted before international or domestic courts. But that does not mean that international law fails to impose responsibility on states for committing international wrongs, for committing international crimes. States do incur international responsibility for international wrongs, for international crimes, and they're obliged to make reparation for the commission of such crimes. That means they're obliged to compensate the injured state or the injured parties. And it's quite clear that Israel has committed international crimes in the form of war crimes, crimes against humanity, collective punishment of the people of Gaza. So it is under a clear obligation to compensate the Palestinian people for the injury it has caused to them. But unfortunately, and this is one of the great weaknesses of international law, there is no competent court with the power to assert these claims, and unfortunately, governments which might assert such claims on behalf of the Palestinians or themselves fail to do so. It's important to stress that many European projects were destroyed in the case of Operation Protective Edge. Projects, medical, educational, cultural projects have been funded by European states, I presume including Belgium, which were destroyed in Operation Protective Edge. States may claim compensation from Israel for the loss that they have incurred, but no European state will ever touch Israel. That's one of the sad facts of international life. They are afraid of Israel, they're afraid of the United States. No claims will be lodged. I hope I'm not being too pessimistic in this regard, but certainly European states have failed to claim compensation for past injury. Finally, there's the question of the responsibility of third states. A state which assists another state in the commission of an international crime incurs international responsibility, if it does so with knowledge of the wrongfulness of the crime. It's not necessary that this assistance should be essential to the performance of the international crime. It's sufficient if it contributed to the commission of the crime. So clearly the financing of a military operation would constitute assistance given to the international crime. Now, we all know that some European states do provide military assistance to Israel, but none do so on the scale of the United States. The United States is the single largest supplier of military equipment to Israel. It supplies up-to-date tanks, fighter jets, helicopters, and missile systems, in addition to funding of the Iron Dome defense system operated by Israel. In the 10-year period between 2008 and 2018, Israel will have provided $30 billion to Israel by way of military assistance. It's estimated that every day, $8.5 million is spent on military assistance to Israel by the American taxpayer. And it's this weaponry which has featured prominently in Operation Protective Edge. And then, of course, there's also the political support that the United States has given to Israel, both by the President and by the Congress. So there is at least a prima facie case for complicity on the part of the United States. Assistance resulting in responsibility may also take the form of failure to prevent commission of the crime. As Israel's most powerful ally, Clearly, the United States could have taken steps to prevent Operation Edge from continuing, but it manifestly failed to do so. And to aggravate the situation, the United States blocked the Security Council from taking firm action to bring Operation Protective Edge to an end. Complicity in and failure to prevent an international crime, an international wrongful act, does present problems in relation to the crime of genocide because of the strict requirement of intention to destroy a people or a part of a people in whole or in part. But it will be much easier to establish complicity or failure to prevent an international crime in respect of war crimes and crimes against humanity. And I think in this respect, the United States clearly has a case to meet. So I will end at this stage, and I hope this has laid the foundation, the legal foundation, for the evidence that you are about to hear. Thank you.